Welcome to Beer and Business. You found the best podcast for entrepreneurs. We serve crafty business knowledge, comedy, and yes, beer. And now it's time for our hosts. If he were to pat you on the back, you'd list it on your resume. It's Jake Mullins. And his beer never gets warm. It just sits there, staying frosty, waiting for him. Mr. John Winnie. And if you spell his name in Scrabble, you automatically win. Ladies and gentlemen, it's Darren Flanagan.
Folks, welcome back to the Beer and Business Podcast. We are live in the studio today with Mike Riesen. Did I say that right?
No, but good enough.
Riesen?
It's all good. Riesen.
Riesen?
Yeah.
Riesen. Okay. I finally got it right, Riesen. So welcome to the show. You are a intellectual property and entertainment attorney, and got a lot to get into with you, so super excited to have you on the show. Thanks for coming in.
Great to be here.
But before we get into that, Mr. Winnie, he's not in the studio. This is for you, buddy. Pumpkin beer. We're drinking the official beer of the Beer and Business Podcast, Line Creek Brewing, and this one's actually really good. So you're drinking 6 Foot Rule, Mike, which we'll get to in a second. But this is called Glow in the Gordons.
You know why?
It's like what? Why?
You don't remember they told us this has to do with the Pumpkin Festival down at Callaway Gardens.
Yeah.
Partnership thing. Oh, I
thought you were
stole your thunder.
No, it's Gardens, but it's gourd.
Gourd.
It's it's called a play on words, Darren. It's nice, isn't it?
Yeah. Mm-hmm.
So typically pumpkin beers are like too sweet for me, or, there's something like I'm picky about pumpkin beers, but I like this one.
This tastes like pumpkin pie. I'm not a pumpkin beer guy, and I'm like, all right, I literally said, and I know Line Creek's going to be like, oh, why is he saying this? But I was like,
I promise it's a compliment.
I'm going to choke it down. All right. I'm just going to get it over with. I'll drink it right away and,
True story.
Say nice things about it anyway. But as soon as I drank it, I was like, oh, crap, this is good.
Yeah, it's got some cinnamon and nutmeg hints to it.
Can I get some whipped cream and put it on top?
But you know what? It's funny. So it kind of taste like pumpkin pie, but it's not overly sweet.
No.
Which is good for me because it's, a little bit of richness. I don't know. You got to try this. This is a really good one.
Say the little cheers there.
L'chaim.
There we go. There you
and Mike, you're drinking 6 Foot Rule, which is actually one of my favorite beers that Line Creek has ever brewed. It's an IPA, and that one actually was a mistake during COVID. And so they quickly converted it to an IPA, and it actually turned out to be one of their best beers ever.
Yeah.
So salvage job actually turned out to be a wonderful, wonderful flavor.
Staple.
Yeah.
6 Foot Rule you can get at
the brewery.
At the brewery, but the Glow in the Gordons.
It's a pun, Darren. Pun.
Gordons. I couldn't see
the
rest
anywhere.
of it. I'm trying to read it off your can.
Yeah, it's
but
delicious. You can actually get that
anywhere
in the store.
The
So go get
store.
some. It's delicious. Or come out and see us.
When?
October 13th. It's a Wednesday. We have business networking. So, Mike, I don't know about you, but you can go to a business networking event at some boring place or a brewery. Which one do you choose? Brewery, of course.
Brewery, yeah.
Yeah.
So come out and see us Wednesday, October 15th, 5 to 7. Just go to www.beer.business and register for us if you would. Yep. It's not mandatory, but we'd like it if you register because we can make sure we got enough, bar staff and food.
And
food. We're going to have a food truck out there.
Hey, how much does it cost?
Well, it's going to set you back a couple free dollars.
$3. We haven't used that in a while. That's why I had to bring that up.
It's not going to cost you anything. So we'd love to see you. Yeah, come out to the next event or just go hang out at the brewery. I mean, seriously,
Anytime.
It's not that bad.
Now the weather's going to start cooling off. They got the fire pit out there. Oh, man.
All right. 'Tis the season. So, Mike, thanks for coming on the show, man. I got to imagine with everything that's happened over the past year and a half with COVID, a lot of stuff getting moved online, the world of intellectual property has probably been pretty interesting.
Yeah.
But what I want to do is just kind of start from the beginning. From a legal perspective, what is intellectual property?
The way to think about it is you got the tangible world around you. You got real property. You got a car, you got a house. What about the stuff you come up with? I mean, you can go out to a store, you can paint, you can buy a canvas, still painting a canvas. But when you create something, a painting out of it that came out of your mind, something you created, there's other rights that attach to that your creativity went into that. That's why we have all these really expensive, paintings, artwork, music. Mm-hmm. So when you come up with an invention or you come up with something that is intellectual in nature, there's other protections out there to make sure that your creations have rights attached to them so that people can't rip you off.
That's so funny because you use painting for your analogy there, and that I was just talking to my dad this weekend when I was up visiting him, and he's like, I wonder what a Bob Ross goes for these days. And so, a Bob Ross painting, I'm like, oh, I just did landscape and stuff. So he gets out his laptop and he's looking, we're looking up Bob Ross. But he went to eBay and it was like Bob Ross like painting. They were using the word and then doing like, and it was like you could get that for maybe 100 to 400. And then he found a Bob Ross original, which was 49,000.
Yeah. Oh my God! Seriously?
Yeah.
Wow.
So
when I guess that's a really good, kind of segue into the fact that this is why intellectual property is so important, because I imagine those two things looked almost identical, but just knowing that it came from the mind and hands of Bob Ross makes that inherently worth a hell of a lot more, exponentially more.
Yeah. I mean, there's something, we call it goodwill that you build up in that brand. I mean, everybody that watched them on television, there's emotional value that gets attached to that. All of that brand gets built around. I mean, this is the world of trademark, and intellectual property really gets broken down into patents, copyrights, trademarks, and trade secrets. Those are like the big pillars of intellectual property. But a lot of people run into trademarks every day, and they don't really realize the power behind it.
Okay, so let's talk about that. What is a trademark?
Yeah, trademark is, the way I like to say it, is it's an identifier. It identifies the source of that good or that service. So we got Bob Ross. Bob Ross became a bit of a trademark because he's famous. But let's look at our desk here. We got Line Creek, pumpkin beer. You have a pumpkin beer, and you're like, wow, that was really good. Who made that? You want to be able to repeat that experience. There's a brand. Oh, it's Line Creek's.
Right.
Right. That's your identifier. So that now when you want to go back and say, hey, what was that? I prefer that over these other versions. Right. So that's your identifier that carries all that goodwill. So whether you have a good experience or a bad experience,
as in the case of Darren,
it goes to the repeatability.
You got goodwill and you got bad.
Well, we had, like last week, we had Dr. Phil sitting here with us, and it's Phil Crane, and he's running for, and he is a doctor of chiropractic and kinesiology. But
there was another Dr. Phil that was a little
Dr. Phil call in who was upset because they were using the same name. You can't trademark your name.
There's only one Dr. Phil, and you know it. You know it, Mike.
So
it's bullshit.
But you can't trademark your name, can you?
Yeah. So yes and no. I mean, when you look at how you're using the trademarks, right? But if you can build up certain famous marks, there's other rights that are attributed to you that is the kind of right of attribution, the right of privacy that attaches to you being famous. So that's if someone says, "Oh well, Darren, I'm going to use your name, all right, to sell cars." All right, that's more than just trademark law because I'm trading on your celebrity status. So there's other aspects of law. Most laws are not just, oh, this is just trademark or this is just that. They all kind of bleed together, right?
Sure what he said, though? On my celebrity status.
I know. Everybody loves you, Darren.
Whew, I guess you got warm and fuzzy inside for a second, if that were actually true.
Jesus.
Thank goodness we've got attorneys like yourself who can help us navigate the waters. But
so let me ask a basic question here about this. So, and I'm coming at this from, obviously I'm not an attorney, I'm not an expert in this, but you got trademark, and then you got like registered trademark, and there. So does it have to be like registered somewhere for it to be an intellectual trademark that you own? Yeah.
So we live in a country that practices common law, similar to like the UK. United, right. I mean, that's where we came from, right? As far as a lot of our principles. We just improved it. There you go. So
we make bacon better than they do.
Way better.
Well, all bacon comes from China now, so look that up. So they bought out all of the pig farms. So,
oh, that's a scary thought. So you said you do stuff in UK.
Yeah, I'm a UK solicitor in England and Wales as well.
So do you travel over there often?
Well, not recently.
Well, the whole thing is, so I used to go to the UK all the time.
Yeah,
they don't cook their bacon all the way. And so it's all floppy and wet. It's disgusting.
I like
Yeah.
that.
Like, who the hell eats bacon that way?
Here, Mike's an attorney over there. He's a solicitor.
That's
You
right.
got the terminology.
I know.
That's
mean,
right. Yeah.
Yeah.
So back to what Jake had just
Yeah.
asked.
Sorry.
Which is registration or not registration.
Yeah.
So under common law, you're going to get certain protections just because you're doing it,
Mhm.
right? Registration it affords you better clarity on what rights you really have, and you also get other benefits there. So if we're sticking with trademark, for example, if I've been using Mike's picnic
Hard
tables.
lemonade.
Okay, hard lemonade. All right. If I was using that for 100 years, it's a family name. We've been using that to kind of identify our particular products.
Mhm.
And I never registered that. I may have certain rights because it's all about use. Trademark is about use. If you're using it, you might have rights. If you're not using it, you might give up those rights.
Okay.
So that's all common law. And it becomes regional first because I'm only using it here in Georgia. Well, maybe some Mike's is selling picnic tables out in Seattle. Not much I can do about it if we're not crossing commercial streams, right?
Okay.
But once you register it, you're getting a federal registration possibly.
Mm-hmm.
Now I'm going to get national notice to everybody. I'm also going to get the right to go into federal court and bring certain actions against anyone that infringes. So you get a broader reach and you get other accesses that you just don't have under common law.
So let me kind of play this out and make sure I understand it. So let's just say I'm here in Georgia, and I have Mike's Picnic Tables, and I've started that business, and we've had it for years. You got this regional notoriety and all that kind of stuff. Well, somebody out in Seattle starts Mike's Picnic Tables and gets a registered trademark for Mike's Picnic Tables.
Yeah.
So then, do they have the right to come into Georgia, even though I've been here under common law operating, and sell another Mike's Picnic Table freely and clearly because they registered the trademark before I did?
That's a great example about what really comes up.
Mm-hmm.
And it's going to become who was there first, who was using it first commercially.
Mm.
So just because the U.S. Trademark Office missed the fact that I was here in Georgia for 100 years and gave the Seattle company their federal registration doesn't mean that's all done. I can go and try to cancel them, right? I can go and say, no, they shouldn't have gotten this because I've been doing it longer here.
So is this why in some parts of the country you go to rallies, in other parts of the country you go to checkers?
There's something more.
gotta imagine
There's something
there's
more
something-
to that though. That
Is there?
I
Totally
used to
different
know. I used to know this more, and now I'm forgetting.
Okay.
But it certainly could have something to do with that, with the regard to before it got purchased by the a certain parent company. They were regional, and they don't want to mess up the goodwill that they've built in those regions.
So
I get it.
keep
Yeah, because I
all the
remember like when I was younger, I lived in Ohio and we had Frisch's, a restaurant chain.
Yeah,
And
Frisch's
then you
Big
go to
Boy.
other places and they have Big Boy.
Yeah.
And it's like, wait, it's the same place, but
Of
it's
course it is. It's TJ Big Boys. They always had the big boy out front.
yeah, but in where I was from, it was Frisch's. So it's like, no,
'cause
it's
you guys
Frisch's.
couldn't pronounce it.
Yeah, I know we're idiots.
So, no.
But this is a very interesting point because I never knew that it has to come. It comes down to who's
Well,
using it first, which is really
I
fascinating.
think what part of that also is people, it's been common practice over the years for people to buy up a lot of domains, website domains, web domains, and sit on them, and
Mhm.
somebody comes along to buy it. And I guess, trademark, if you're traveling around and you see all these great names and you're like, hey, they're not trademarked, and you try to scoop it up and capture it to get that leverage to, down the line and go, oh, you're going to do this. Well, I already own this name. You're going to have to pay me a lot more to do it. So with the time continuum or the time, who's been there longer, that helps protect the common man.
And
So-
use. The other big thing is use. It's not just who's been there longer.
Mhm.
It's who's been making commercial use of it.
Okay.
So if I go out and I sit on a trademark, I trademark something, and then I don't use it, I don't operate the business, or I stay really hyper local and never expand out into the country, somebody else may have the ability to go use that mark before me.
That's
I guess
right.
is what you're saying.
Yeah. I mean, it could get
It's always
peeled
complicated
up. Yeah.
with lawyers. You know that, right?
Well, it's getting to the right answer can be complicated
I know.
sometimes.
That's why you guys get paid the big bucks.
That's right. But no, I mean the way I always look at it is everybody comes up with their trademark and they're like, oh, this is it. I didn't see it. I don't see anybody out there with it. They're always pretty disappointed to find out that there's something close.
Yeah.
I mean, come on. Let's just look at it. There are people opening up all kinds of things all the time. That doesn't mean it's over, because you really have to look at what piece of the pie do you actually get. And what really helps is there's a spectrum here. On one end of the spectrum, you have a mark that describes exactly what you're doing, and that's not good. The federal government won't give you protection. So if I'm selling apples, it's Mike's Apple Orchard, and I call it apples or Apple, Macintosh. That's not good. That's telling you that's describing what I'm selling.
Okay.
On the other end of the spectrum, it's completely arbitrary. Okay.
Nike.
Nike, I think Nike goes back to at least a god though, right?
Yeah.
Greek god or mythology.
Okay. Yeah,
so I'm saying,
like-
so there might be a connection there still. So you're still on the arbitrary spectrum, sure.
Yeah.
Because you're talking about sports apparel and things like that, but like completely made up, X55 apples.
Right.
What is that? What is that? I don't know. It's completely arbitrary. It has nothing to do with apples. Those become the strongest marks because they're coming out of nowhere. I have to start from zero and build all that goodwill and to convince people.
That's interesting.
What's X55? It's the best apple I've ever had. Once you get that, that's the strongest type of trademark because it's arbitrary and you build the goodwill in it.
I wonder if that's why Beachbody made P90X, because Beachbody isn't really that strong of a mark, because I guess that's like common vernacular.
P90X
right?
was made by Navy SEAL, wasn't it? Or that's the other guy?
Maybe Beachbody bought it. I don't know this
bought
to
it.
be true,
I
but
don't know.
P90X
maybe
was,
he came up with it, and then Beachbody, as a larger distributor,
Maybe.
came along and said, "Hey, this is a good system. Let's put that in our storehouse." I don't know how it went down.
there's a good question about that later that I want to ask, because it has to deal with with the P90X.
What the hell are you talking about?
But I do have my simple
This is
question.
what you have to deal with when you get interviewed by Darren. Hold on, there's a question. I got to put it over here.
He's giving a preview for the next
He's
hour.
warming up. He's
That's
warming
right.
up like an old car.
Takes a while. But my question is, how do you know if you actually have something that should be trademarked or you have intellectual property? I mean, most people don't know that. I mean, Launch and Go Workspace, right? I should probably trademark that just because I don't want anybody else using it. But how do you know what do you trademark, what do you not trademark?
Yeah, and again, we go back to when you start using it, you're getting common law rights. You put a mark on something, whether it's descriptive or whether it's arbitrary, wherever on the spectrum you end up, if you're using it that way, you have common law protection. Now, it could have holes in it, but you've got something, right? The question is, when do you want to invest in it to register?
Exactly.
When do you want to put more in it? And that's the reality is, if you're doing anything commercially, you probably have IP. It's highly likely. You at least have copyright because you're making collateral. You got a web page. So all of this stuff, there's IP everywhere you look. It's never really the question of, do I have something that needs to be protected or not? The question is, should I spend money on it to help my protection?
And what are some good indicators besides just saying, Mike, I'm going to hire you to tell me if I should really put the money into this and protect it more? I mean, are there some, like ABC, if it checks these 3 boxes, you should probably invest some money in getting this thing registered?
Yeah, consistency is probably a good indicator. If you've got something, whether it's a web page, whether it's a logo, whether it's a name, and you're like, this is it. This is I'm going to ride with this for 10, 20 years. That's probably a really good indicator that if it's going to be out there commercially and it's something, my first mentor said, you don't want to go out and have to repaint your vans. And that's really, really bad.
Yeah.
If you're Frisch's and you're selling hamburgers for 30 years and then someone comes along and says, whoa, or 3 years, let's say, you're just getting, you're on the precipice of making it great. And someone says, you can't call it Frisch's anymore. And you got to turn around and rename it. You lost 3 years.
Well,
That's a good point.
Think about that with the Kentucky Fried Chicken, right? We used to, it just all of a sudden became KFC. It was just common speak for everyone just to shorten it instead of saying that. And one day they finally picked up on it. And what did they do? Now they shorten it. Now
Plus it's not
KFC.
chicken. You got that whole problem.
There is that. But
Can I get in trouble for saying that legally? Be honest.
It's,
He's like, I don't know how to deal with these guys.
Just write a check, and here's what my retainer is, Jake, and then you can have it.
He's going to be on retainer by the end of the show, unfortunately.
or fortunately.
It depends on which side of the table you're on, doesn't
That's
it?
right, literally. So, really the question, the answer to that question, I'll say is this: truth is an absolute defense to defamation. Meaning, if someone brings a defamation suit and it's the truth,
Yeah.
you're good.
Okay.
Yeah.
So just hope what you're saying is the truth.
Yeah. So going back to the trademark question. So one of the things that I have a question about, because I've been involved in some trademark things with a big company, but it's like a deep, vast black hole. Like I had no idea what was going on with the brand team when they were doing that. But if I've got something as a small business and I'm like, I think I should probably trademark this. How involved is that process? Like, what does it cost? Like, give us some scope here if I want to trademark something.
Yeah. So on the spectrum of all IP, trademark is on the lower end of the spectrum with cost, or can be. Filing an application. This is why you have like LegalZoom and all these. Because why? They're like, oh, let us click here and we'll help you do an application for $100, whatever it is. Because there's a general form to it. I mean, the U.S. government, federal government, does give you a lot of support as an entrepreneur, as an individual, to kind of walk you through. This is what you need to do. They really do. They kind of line it up, and they're like, this agency is, at one point, the patent office was the only agency that was profitable. Actually turned money back to the
Notice
government.
he said past tense was.
I haven't looked at the numbers recently.
They
but,
turn money back
well,
to
if you looked at the budget, they were actually
within budget.
making money. So,
Wow.
so they have a lot of good resources, is what I'm saying. So uspto.gov, that's for patents or trademarks. A lot of good resources. Click through, learn a lot. But the basic answer to the question is, it's $300 and some to file a federal application for a trademark. That's what it costs you to pay the government to process your paperwork. The reason that trademark attorneys would say, no, you want to go through us, is because what you put in that application could change the way the government looks at it. So it's not that bad. You fill it out, you send it in, you pay your $300. You might get a trademark out of that, but maybe you didn't scope it out the way you should have. So now you want to sell T-shirts instead of just beer.
Right.
And you're like, oh no, I have that. I have a trademark on that. But no, you don't have T-shirt covered. You have
Your
beer covered.
merchandise. Yeah.
Yeah. So you're not really thinking about that next thing. That's where the consultant comes in. That's where the attorney could be helpful. But the actual application itself could be done. It's just what typically happens, and we always get the call afterwards. Hey, I did this 2 years ago. Now I need to stop this company out in Oregon, doing this, and they're stepping all over this. Help me out. And here's what I filed. And we're like, not much you can do now. You didn't do it right. That's why I would say it can be done relatively expensively.
It's only federal, right? You don't file for trademark on a state level.
You can.
You can.
Yeah, there are state protections, and a key distinction. I get this a lot as well. Well, I filed with Secretary of State. I've got a business name, so I'm all clear.
No.
Nobody's doing diligence. Nobody at the Secretary of State in whatever state you're in is doing any trademark diligence. So separate agencies.
If the difference is $100 and $300, why don't I just go to the federal level? Which one supersedes it though? I mean, when it comes to if you are taking a court or there's a dispute, does state supersede federal on the trademark, or is federal over state?
Well, you're applying different laws.
Okay.
Right, and different laws are going to afford you different, regional protections. So in Georgia, you can take it to state court, and you can resolve it in state court. You could also remove that to federal court if you have both, and they can hear both of them. But it's not like the facts will be in conflict with each other. You're just applying two different sets of laws and two different remedies, both in the state or the federal.
But going back to what you initially said, the ultimate resolution is who's first, and all that kind of stuff, and what protections you have in your trademark if you did that. That's fascinating. And it's if I'm hearing you correctly, I'd imagine that the overall cost of the trademark process, especially if you're going to use an attorney, is probably going to depend on the scope and how granular you're going to get in those protections and all the things that you want to bring into it. So the bigger the scope, probably the more the cost.
Yeah, and once you get it filed, it doesn't mean you're done, because it gets assigned to a trademark examiner
Mm-hmm.
at the federal government, let's say. And if they like the application, if you did your diligence, if you talked to somebody, that can help smooth that out. But they could reject you. Now, what do you do? Do you really know what to say to argue, legally speaking, how to get over that rejection? So that whole thing that we call that prosecution up and until you get your registration, that's also a time that we get phone calls because they're like, hey, I filed this. Now I got a letter back from the government and I'm supposed to respond to them. I don't even know what to say. So these are the times. But, all in all, I would say it's a few $1,000s, to get a registration. We often recommend that you do some kind of diligence because it's crowded. You don't want to spend that few $100s or even a few $1,000s if someone else is already out there standing in your way. So that upfront diligence to find out if other marks are out there conflicting with yours, it's pretty important.
I had that with Lunch and Go, trying to come up with the company name. And this was the original name. But I went through other names, and all of a sudden it was like, okay, I'm good. And I mean, I researched the hell out of it myself. I probably should have used an attorney, but I did it myself. And one day I'm talking to a guy about one of the vendors that I'm working with, and he goes, are you part of the group that's over here? And, they've got the offices there. And I'm like, who are they? And I'm like, what's their website? And their website was totally, just their name was different than what on the website than their actual name. And they ended it with a .io, which probably so they could get it super cheap. Instead of $12, they paid $2. And I'm like, oh, crap. I got to start all over. And I'm like, forget it. I'm going back to Launch and Go, because they already had something else. And Launchpad is what it was. I didn't think about it. And similar colors to their stuff. And similar, oh, shoot. I really would have probably gotten into a jam. But
Yeah, and I think this is an important conversation because, really what we're getting into I think one of the things that's happened over the last couple of years is we've seen a lot of people get into side hustles. They've lost their business. They're looking at other things, and internet businesses are becoming easier to get into. And so, like, one of the things I think about is like, I know somebody that they've got a side hustle, like designing these little T-shirts that are, funny little sayings, and they've kind of taken off, and they're, you can buy them anywhere. Well, what's stopping somebody, from just stealing their designs and starting to sell them on their own website? Because they haven't done any type of formal registration and trademark on their designs, and they could have copyright, I guess, from the stuff that they're creating, but it gets into this area where I really don't know what the rules are, and somebody could start stealing their designs, put them in similar places, advertise in similar places, undercut them on price, and it confuses the market, and that can be devastating to a business.
Yeah, let's talk about copyright since you brought it up. To distinguish from trademark, whether it's a logo or a word, it's all about how you use it.
Right.
It's not just, oh, here's my design that I put on a shirt. It's saying this is an indicator that this is the source of this shirt. This is Mike's designer T-shirts, right? The copyright can be anything that you bring into a tangible medium. So that could be the music, could be audiovisual, or it could be artwork. So even if it's just the way that I lay out my T-shirts, what if I have a really unique way of presenting my quotes on the back? It's the same thing. It follows this motif of presentation. I can copyright each one of those. Now, copyrights are really inexpensive, and there's a huge payout when you register with a U.S. federal copyright registration, and that is you can get the benefit of what they call statutory damages. So let's say I'm just a small shop. I'm selling T-shirts. I have a really cool design. I created it. It's my own authorship. It's my own artwork, and people love it, right? It's like, the new, what is it, Guy Harvey, artwork, but people are just selling these things. I can register my picture that I sell on these T-shirts for like $35 to $50 with the U.S. government, but it's each artwork,
picture.
each copy, right?
Mm-hmm.
Once I have it registered, then if someone comes along and I sue them because they're copying it, normally you have to prove to them, hey, I've been damaged, and here's my damages expert, and here's how much I should be paid. But if you have a U.S. registration in copyright, the judge can give you statutory damages, which no matter how I've been harmed, by statute, he can say, hey, here's $100,000 per infringement. Here's $25,000 per infringement, regardless of
Even if I wasn't damaged.
that. Well, even if you didn't have $25,000 worth of damage.
Dude, you are damaged. Okay.
Oh, that's true.
Just saying.
Oh, yeah.
That's incredible. I mean,
That's been proven.
well, okay. So talking about this copyright for that, let's talk about fonts.
Okay.
If we can, because there are so many fonts out there that are for common use that we can use, but there are certain fonts that are registered, right? They are copyrighted because somebody's created their own unique font, and I guess they register it as art, or how is that? So it's protected as well.
Yes.
And they create it as a font, like you could have Mullins whatever font, and
Well,
can he copyright his font if he does like all the uppercase and lowercase lettering for that and says this is my font, and if you're going to use it, you're going to have to pay me, and if not, you're screwed, and I'm coming after you.
So when you ask a broad question, the question it really comes down to, was there actually something new that was created?
Right.
If
Well,
we
Jake could actually write the entire alphabet, that is new.
well, it may be new that he only has 17 letters in his alphabet. That could be the new part of it, right?
That is true.
There's 17 letters in the alphabet. What are you talking about?
Exactly.
There's
Thank you.
57 countries.
Yeah, there's 57 states, right?
But if you've got a new work, a new artwork,
Mhm.
whether it's the way you stylize your calligraphy or your font or whatever,
Mhm.
if you can present that this is a new work of authorship, then you can have copyright ownership in that.
Okay.
Yeah,
And rights.
the font for Beer and Business is copyrighted. I had to pay for it.
Did you?
Yeah, absolutely. Yeah, so I mean, really, you can copyright anything that's a work of your talent, your creative
Yeah.
talent, right?
If it's new,
Mhm.
you get into a whole. We don't have time to get into too much of this derivative work,
Sure.
which means that I really took theirs, but I changed it.
I made it my own.
But I changed it. Now you get into a question of, well, is that just a derivation of what they already had, or did you really transform it to something new? That's a whole can of worms, but it's a fun can of worms.
Mike's like, we don't have enough time.
And then do you
because
have the
I know-
rights to what you originally started
Right.
with to make the change too, right?
Yeah,
So
all kinds of
all
things.
kinds of crazy stuff. Yeah, I've actually got some experience with copywriting because I copyrighted my book and I've copyrighted some other stuff with our website and my other business. So, and it is pretty easy.
Yeah,
Like
it is.
If I can figure it out, folks, you can do it.
It's very powerful. Copyright's powerful. Trademark takes a little more investment because you have to do your diligence, or you should do your diligence, and then
Yeah.
you got to stick to it and use it.
So let's go back. So the pillars of IP. So it was trademark, it was copyright. What were the other pillars?
Patent
Patent.
and trade secret.
Trade
All right. So let's
secret.
talk about patents.
Yeah.
Because I think this is a fun conversation because you can, I think a lot of people might kind of reserve patents for just like, oh, I've got an invention. Like Nick Nolte in his garage comes up with some great idea.
No.
But it's more than inventions, right? There's a lot of things that could be patented.
It's just inventions.
Oh, really?
Yeah.
Well, okay, so products.
Okay.
Like an invention doesn't have to be a product. It
It could be a product. It could be a process. Yeah.
Right, exactly.
Yeah, exactly. I
Sorry.
was busting balls.
Like-
So,
Cold-
Thank you for that.
yeah, yeah.
Like you could have a patent. What was it? The one guy we had on with the peppers. He was doing a cold press type way
Yeah, of making his
Of
sauce that
making a
was
sauce.
nobody had done
instead.
before. So he could patent that process.
The process, correct. So
If it was very specific and he can prove that nobody else has done it before, or is he the one who's perfected it?
well, it could be either, actually. So it all comes down the standard for patenting.
Mm-hmm.
And by the way, just to be very clear, you can't patent an idea. Okay, like you've got an idea, you've got to actually describe.
You got to sketch it out.
You got to describe. The rule that we use, well, the rule that of law, is that you describe it such that somebody that's skilled in the space that you're teaching
Mm-hmm.
would be able to read your patent application, and without having to go out and kind of reinvent everything, could practice your invention. So
Right.
do you have enough guts behind it to sit there and say, hey, it's kind of an instruction manual,
Mm-hmm.
right? You don't have to have all the nitty gritty detail, but you need enough that someone picking it up that knows enough about that, they could actually go out and make it work,
And replicate it. and do
replicate it. Okay. So
So can I just stop you right there?
yeah,
So you could come up with an invention on some sort of widget and never actually build it.
Correct.
You could just write it down. Like if you were to build it, you'd build it this way.
That's right.
And then you could, and if you were awarded the patent, then you have ownership of that idea and somebody would have to pay you for it to build it.
That's right.
Okay.
Yeah. So to restate that in the patent world, what do you get?
Allow me to say it smarter than Jake did.
Right.
No, just one addition. If you have a patent, what does that give you? I guess that's the big question.
Yeah.
I have a patent. What does that give you? It gives you the right to exclude others from doing what you own in the patent, what you claim.
So
Okay,
Jake has in his patent that they used a hair dryer and a hot glue gun and a soldering iron to create. That's a true story.
That's actually a very true story. Yeah, I repaired a drone remote with a hair
Mr.
dryer
Winnie.
and some. Yeah, it was. I should have patented it because
And a lot of bourbon.
it would have gone down under the hillbilly patent book. I don't know if that's the same book as all the smart patents, but yeah, we totally hillbillied something. But going back to the point, you don't actually have to have the widget. You can have the idea, or it can be a process.
Yep.
Or a method.
Yep.
Of doing something. So like think about like a method of training, right? You could patent like, oh, I've got a new idea on how you train something, and so you could sketch that out and apply for a patent and possibly be awarded.
Yeah, that's right. The key elements to get a patent through the government is it has to be new, meaning nobody else has published it or sold something that is exactly what you're trying to invent. That's a pretty easy determination. They either do or they don't. That's it. The next one is really difficult, and they call it obviousness. Is your invention obvious in light of everything else that's out there? And that it's not as simple as just saying, well, it seems obvious to me. It's a legal standard. There's a lot of court cases out there that give us a guidance on how to figure out what it is that makes it obvious or not obvious. But that's the tough one. That's like, let's go back to your process. Is it obvious that bourbon, a hairdryer, and hot glue gun would have been the things that somebody skilled in that space would go to fix it?
Absolutely not.
See, right?
Only an idiot.
Well,
only an idiot
So
would
these
do it.
and these are exactly
Not
the
just
arguments.
one, but two idiots.
Two idiots. Yeah. How many idiots does it take to fix this? A couple.
So if you were in that fight and the patent examiner and the federal government came along and said, no, this is obvious, and you would say, no, let me explain to you how not obvious it was, right?
Yep.
And you would go back, and that's the argument. And if you convince them, they would say, wow, you really are idiots, and here's your patent.
Congratulations. I don't even know what to say, guys, but here you go.
That's
You need to write that up. Here's how to repair this section of a drone.
So, so here's what I think is interesting. So, are you familiar at all with some of the Well, let me back up. I want to ask a question. So, if you get awarded a patent, do you own the rights to that process or that idea forever?
No.
So, how long do you have?
It depends what kind of patent you have, but we'll say 20 years.
There's different kinds of
And that's if it has usefulness or utility. You can get a design patent, which is maybe it's the shape of this can. So it has no real utility. It's just the way it looks, right? And that can have a different term to it as well. Okay, 14 years, whatever the term, 15 years, depending. But this is all country by country, by the way. You don't really get a worldwide patent. You don't get a worldwide trademark. There's treaties between all these countries, right? But you have to go country by country if you have a bigger global business. But back to the question, does it last forever? No. In fact, that's the big exchange. The reason you're getting a monopoly or an exclusivity is because you're teaching everybody something new.
Right.
And you get to own that for 20 years, and then it's dedicated to the public because that's how we advance.
And
That's how we
sometimes it's
advance
not 20
technology.
years, right?
Well,
Sometimes it can be less.
Well, the term is 20 years, but it can be reduced based upon certain activities.
So let me give you a great example because I think this is one that everybody will resonate with. When the iPhone came out, Apple had a tremendous amount of patents that went into the design of the iPhone.
Yeah.
And it really precluded competitors, even Google with Android, from creating a competitive product for years because they had so many slick patents that went into the design of that phone and the UI and how it worked, that, you know, there were other things that would come out, but you're like, God, this is so stupid the way you have to do this. It's like, yeah, because they can't do it the same way as the iPhone because it's patented. But I don't think that they were able to hang on to some of the patents for 20 years. I don't know all the details. I think it had to do with the fact that it became so mainstream, and because
You still can't swipe. That's one thing that Android does have when you're texting and stuff. You can do the swipe thing, and I'm assuming that was probably a patent for Android, and Apple can't do it. But another way to phrase it. So go ahead, finish that.
Well, yeah. So I mean, is that a good example of showing people, like, first of all, how valuable that can be, even the little things like, you know, the way that you message and the way that the music app was brought in there. Like they had the market cornered for a long time, and their market share was unbelievable for years.
And I'll share a couple of responses to that.
Okay.
Number one, the patent term is the patent term, but if you get into a battle with somebody, the first thing they may consider doing is trying to kill your patent. So just because you have a patent doesn't mean that it can't be revoked. All right. So let's say that you have a patent, you sue me. First thing I'm going to do is I'm going to study your patent to see if it has any holes in it. And I say, well, wait a minute. He says this is new. His invention existed 3 years before that. I have proof. I have proof that he did not invent it. Someone else invented it in Singapore. And here's a publication that explained everything about it. So I'm going to bring that to the court. I'll bring that to the patent office and say, hey, let's go back and invalidate this patent. Never should have happened. And here's why it shouldn't have happened.
They scooped it.
So now you made all that investment. You got your patent. You sue me, and now I kill your patent.
Wow. And do lawyers ever? And I have no idea how this works. So I'm just asking an idiot question.
They go to school.
So folks, I'm asking dumb questions on your behalf. Do lawyers ever get together and say, hey, all right, Apple, so we know you got some good stuff. We really don't want to get into court and make this all messy. Like, I've got some things here that we might be able to poke holes in the patent. Can we negotiate, a favorable purchase of the rights to that? Or can we negotiate that you yourself let go of the patent 3 years from now, or whatever the case might be? So is there ways that they might negotiate outside of court but knowing that could be their leverage on the back end?
Yeah, absolutely. Because it costs money to litigate.
Yeah.
And, depending on who the plaintiff is, the patent owner that has these rights, maybe they don't want to go the distance. Maybe they're happy if they just take a small license fee for every possible defendant that's out there. So now they've got these licenses that just build up. And then the defendant, the one that's being accused of infringing, they're looking at it and say, all right, I can pay lawyers $1 million to make this thing go away, or whatever the number is, or I can pay the plaintiff $25,000 and it all goes away.
Mm-hmm.
Yeah.
So negotiation happens a lot. In fact, most patent cases that are brought in federal court, I would say the majority are settled. They don't go all the way to trial, is what I'm saying.
Because here's what I do know, because I don't know a lot about this, but what I do know is when the iPhone came out, they held some really badass patents. Because if you remember back when the iPhone came out, the first iPhone came out in 2007, if I'm not mistaken. And when it came out, every phone before that had physical keyboards. And that was the first one to come out like fully virtual. And people were like, that's the dumbest freaking idea ever. You can't have a phone without a keyboard on it. No, nobody's going to use that. So they were able to get patents on stuff that people thought were stupid until they used it.
Yeah,
and then it's like, oh, now that's pretty cool. And so they just cornered the market. And I got to imagine, I seriously have not researched this, I don't know, but I got to imagine there's probably a lot of lawyers between, other manufacturers and Google and Apple negotiating some of these things that Apple had the market cornered on. And they probably had to acquiesce because they just as much as they want to capitalize on everything they can, they also don't want to get into a monopolistic situation where federal government might step in, say, you got really, really exorbitant market share here.
There is a crossover between antitrust and patent rights that that is also an interesting, maybe academic, discussion. But
Yes.
maybe after 7 or 8 beers, we'll get into that
Let's
one.
go way back to the Vanderbilt. So we'll start during the 10th century although right now, I'll tell you what, traveling this weekend and still having to always wear a mask when you're traveling, I'm like, I wish I had my phone with that thumbprint thing back on it again because I don't want facial recognition. Drugs, pharmaceuticals. Should have rephrased
He's
that.
like,
Sorry.
Drugs. Welcome to the mind of Darren Flanagan, folks.
No, but pharmaceuticals are huge when it comes to patent law. I know Viagra was a big case, and I know
Wow,
no
Darren,
pun
way,
intended.
way to go.
No pun intended. That one came out
We
wrong.
hope so.
But it was, they had a patent on their product, and other products are the same way. And it's like, when does that patent end so they can make the generic version of it finally? And that's
So
a
they
big
finally
thing.
have some stiff competition.
No. I was trying to refrain.
Thanks, Darren, for
I was
bringing
trying
that.
to be good one day.
This is a hard conversation to have.
There's Jake just shooting off too early again.
Welcome, folks.
So anyway,
He's done.
damn it.
He's done.
If there is a pharmaceutical product that will benefit the country, we'll say a COVID product and a vaccine. We'll use that as an example. Instead of it's for the greater good, and if it is under patent at that time and they realize that it's for the greater good of the population, can the government step in
Can I expand on your question?
Yeah.
If somebody came out with a miracle pill that cured cancer,
Sure.
that'd be a good
Be a
example,
great
right?
one. Yeah.
So what protections would the drug company have on the patent? If they wanted to charge $10,000 a piece because of their
Right.
R&D, can they do that?
But can the government come in and say, this is going to help everybody and eradicate this? We want it now, and it needs to be cheaper for the general public.
Yeah, there are a lot of areas that come into this whole
Sorry.
question.
Thanks for asking the most complicated question you could possibly ask, Darren. Thank you for that.
The first piece I'll say is, we look at the line between government subsidized and pure private.
Mm-hmm.
So if the U.S. government gives you a grant to develop, they already have rights in your patent because they help pay for it.
If the
research.
government helps pay for it.
That's right.
Okay.
So all these, you look at National Institute of Health, they give out how many millions of dollars a year in grants.
Mm-hmm.
Each one of those, if it leads to intellectual property, has an ownership grant all the way back to the U.S. government. So that's how they deal with a lot of this if they grant it. What if it's purely private, though, you say? Well, that's clearly under the patent laws. They
Okay.
get that. If the government comes in, there's lots of constitutional questions that come in. One of them is that the U.S. government overstepping their bounds and making a taking? So that's a whole group of constitutional experts out there that would be able to kind of get into that academic question of, can they do it? If they do it, what's the compensation model? Was there any precedence for that, et cetera? What's the basis to do that? Because it's going directly against these other provisions
Sure.
under the patent laws.
Well, it's like, now we'll bring it up. You have Pfizer, Johnson & Johnson, and Moderna, right? They're all private companies, and they're doing this, and none of us have to pay for that vaccination, but somebody's paying for it.
It's free.
Right? Yeah, it's free. It's free.
It
At least
doesn't cost anything.
it's free here in the United States. I don't know.
Well, the
about
government can
other
be a
parts of the-
contractor to private
Sure,
Government
exactly.
can be a
Happens all the time.
contractor.
Because that's what they
but
did, right? They bought it.
Yeah.
They bought it,
They
but
bought it from these
they bought it
companies.
at a premium price. Right? They didn't get it at like wholesale cost. How much did it take you to make the product? That's what we're
But
going to pay you.
if I may, because kind of going back to Darren's ultimate point about the greater good, there's been several examples in the courts where pharmaceutical companies in particular have charged a lot of money for drugs,
Mhm.
but they had a lot of R&D and they took a lot of risk in developing those drugs, and ultimately their patents held up.
Yeah.
Right? Because unless there was something wrong with the patent itself and there was a hole in it, like you were talking about, a lot of times these hold up because yeah, they spent money, they did the research, they came up with a drug, and if it's $1,000 a dose or whatever, so be it. That's your right as a private company. You may not like it, but usually they get upheld, right?
And not every drug's a winner,
Right.
No.
right?
Okay. Well, we'll take insulin, for example. That's a necessity for diabetics. And people, insulin is something that they need and will die without, but they still are charging a premium for that. And at what point can that be like capped? And somebody says, no, this is where it is. This is somebody has to be able to live today without this, and you guys aren't allowed to charge as much as you are.
Again, I said before, there's elements of antitrust that come in with patents in the same way.
Okay.
So there are other levers that can be pulled.
Okay.
And someone could say, hey, they are flexing it because they have this whole majority of the market. They're keeping competition out, et cetera. Are they overstepping? So
Right.
there's lots of things that can be brought in. If I shift it away from drugs, but make it another comparison in telecom, they have these standard patents. So they come along and they're like, hey, this has become the standard. Everybody using a mobile phone, everybody on 5G will be using this standard protocol to send their text messages. And I have the patent on the protocol. There are bodies now that you subscribe to. You say, all right, this is the standards body. There are other rules and laws that apply. And then you get a reasonable royalty because you have the standard. It's not like, hey, I'm going to keep everybody out. But there's you.
But is that an antitrust issue, or is that patent, or both?
It's both. But in the standards position, there's a couple different ways. You've got standards. You also have patent pools, which is the election. Right? We all get together and we say, hey, you've got a great patent on lights. You've got a great patent on 5G, and I got a great patent on drugs. It never happens this way. It's usually in the same industry. But let's say, let's all get together and share that. And the three of us can all kind of, because let's say we're multi-conglomerate. We got a lot of different branches, and we're going to share that. We could pool our resources together amongst us. Right. And anyone that joins our team will get the benefit of having a license to the pool. So that's one way to do it. Standards are very similar to that. Who's part of the standard? If you're part of the standard, then you pay your dues, you get your fee, you pay your license, but it's agreed upon.
So if I could, because I want to, this might be a bad example, but I want to kind of put a finer point on this. So one of the reasons why patent law is so important, and the reason why sometimes we may not like it, is let's say that, and I'm totally making this up, okay? So this is total bullshit, everybody. But let's just say that I was the guy that came up with the idea for the seatbelt. Never manufactured a car.
It's called Ralph Nader.
Shut your face. I'm making a point here. So I come up with this idea for the seatbelt. I never made it. I'm not in car manufacturing, but I had an idea. And I was able to write it down and design it on a piece of paper. And I put this patent, application out there, and I got it accepted. And then I took it to a car manufacturer and said, I've got an idea to save lives. And bam, I show them this thing, and they're like, that's brilliant. And all of a sudden, everybody picks it up. And my idea changes the world. My idea saves lives. My idea does this. And because of my protection under the patent laws, I'm able to monetize that, and I become filthy rich off my idea. I become filthy rich, but I'm the guy that invented seatbelts. So don't I deserve that? And I think ultimately that's kind of one of those things where when it comes down to patents, if your patent's good, that's one of the things that could happen. The protection is that was your idea. You changed the world, and therefore, you deserve to be compensated for it.
Yeah.
Right?
Yeah. It really goes back to the Constitution, at least in the United States. The Constitution, paraphrasing, says that you need to protect, arts and science and the development of arts and science. So then you come down to if the Constitution says that, the laws that are implemented are the laws that came out and define copyright. They define trademark. They define patent laws, all under this edict to say, hey, we got to protect arts and sciences. So the capitalistic approach to that is to say, if you're going to spend time and money to make the world better by inventing things, like if you're going to dedicate some time to do that,
right,
we're going to reward you.
Sure.
You're gonna be able to get that for 20 years, but then you've shared it.
When did the copyright and patent, when did the U.S. Patent Agency come into yeah, never mind. You don't have to answer that. I'll look it up. Sorry. I was thinking way back. I'm like Edison and Tesla and all that stuff.
USPTO is old.
Right?
Yeah, it's
been around for a
1800s?
long time.
Yeah, it's really old, and then there was a big fire, and then they lost records, and they had to start over.
Yeah, you're
and stuff.
right. I
Yeah.
remember. I read about that. Yeah, you're
Right.
absolutely right. But so going back to your point, so like in my example where I just come up with an idea, but I act on it, and I go out and I sell it, and I become filthy rich. Well, congratulations, you changed the world. You deserve it. But in your example, Darren, of the drug companies, well, a lot of times these drug companies spend incredible amounts of money, take huge risk, hundreds of millions of dollars. The most talented scientists in the world, they're paying them, trying to compensate them to come up with ways. You come up with the miracle cancer pill. Like if somebody comes up with the pill that causes cancer, I want that company.
Or cures.
What's that?
Or cures.
What did I say?
Causes.
Or cures.
Wow,
causes
Line Creek
cancer.
is really good today, guys. I don't even know what the hell I'm saying. Sorry, cures. Thank you for correct. Gee, many Christmas. How many? I switched over to 6 foot rule. What is the alcohol by volume?
They're
Oh, it's
both
only
high.
6.3.
I mean,
Maybe I'm just losing
the
my mind.
pumpkin beer is a 7.3. So don't think you're tiptoeing through the
I know.
tulips when you're drinking that one.
Yeah,
today,
I'm
folks.
sludging through
Well-
it. But seriously, if somebody comes up with the pill that cures cancer, I want the company and I want the scientists to be filthy rich. They deserve it, right? I mean,
Yeah, I
It
mean,
is.
this is
that's but
the
that's,
the
that's
bigger
why
the bigger
they do
debate.
it.
You
It's
can
the
quickly
motivation.
right. Well, so this is the argument. This is the counter argument is always, well, that is the argument. Will innovation stop if there isn't a carrot?
Yes,
You know, and that's the big question.
it's human nature.
Is
Of course it will.
right. Is there a higher moral drive that will keep people going, keep
No.
people fighting, you know, for that? Or
COVID has proved that. No,
so
you pay people.
The old
Listen,
altruism is out the window. Let's put it that way.
You give people the option to sit at home and take unemployment or go work for the same money. We saw what happened. I mean, unfortunately, the carrot needs to be out there. I think. I think that the motivation, and it's why all of us try hard. You know, think about it. You go to school. Are you going to bust your ass and study hard if everybody's grade gets averaged, and it's up to the class?
Are you going to start just because you showed up that day? For
I know
whatever?
everybody's
Good
going to get less. So
job,
that
you got
I
one.
absolutely believe whether this exists in you know countries that you deem as capitalist, which you could argue whether or not ours is actually
It's
capitalist
only 3.
or socialist. I mean, the reward function is there in pretty much any functioning society. So I think that it's paramount.
and let's take this. We're talking about Fortune 50 companies. Let's take it down back to the entrepreneur.
Mm-hmm.
There's so many instances where a startup decided to make investment because the technology, the invention was so core to what they were selling.
Mm-hmm.
It was their process, it was their product, and it was truly IP. So they got a patent on it. And there's so many instances because if you're a startup, you may have huge competition, or you most likely have other startups that are your competition.
Mm-hmm.
And that initial chilling effect is the word that we like to use in the
Chilling
industry.
effect.
Is you sit there and say, I got the patent. So now, you know, you're my competition, Darren. You're my competition. You come along and I'm like, hey, you guys can't do this. So even if I don't get $1 billion because you don't have $1 billion, I get you to stop because I get to own this market right now. That was the deal. That's why I have the patent. Now imagine what that does to a startup. You know, this is core to the technology. And now I get that exclusive right. I stopped you two from getting in my space.
Right.
So I get a year, 2, 3 year jump. Even if something happens later on, even if someone comes and makes an improvement, that was the key to getting me started and to making that difference. So
I've actually
it could be
seen this
impactful.
happen.
Yeah.
I've actually seen this happen. So this was not when I was at AT&T. So I'm just going to put that
Oh,
out
thank
there.
God we don't have to listen about your days at
But I'm-
AT&T today.
I know, but I do want to share. So I'm not going to give the specifics because I do not want to get in trouble. But I used to, in another large industry I worked in, there was
You used to be
there was a smaller company that came out with this little piece of technology that was pretty much a game changer in that industry. And the company I was working for went after them, army of lawyers, like big time, because they were stealing customers because of this technology. And they were a very, very small fish in a very big pond. And they went after them guns blazing. And this company ultimately ended up getting bought by their bigger competitors for an enormous sum of money because of their patents. So their patents protected them. It was a David and Goliath story.
That's good though.
But
for
their
them.
patents, the fact that they had good patents, saved them because they were small. They had Lionel Hunts going into trying to help them in the litigation against these armies of lawyers in $20,000 suits, and they won out because they were protected. And I think that's what you're saying. Like you can absolutely, that could be the difference maker, the linchpin on whether or not you're successful.
The tough thing is with startups, entrepreneurs, is patent side of things could be one of the most costly of the IP pillars, just to get filed, to get prepared correctly. I mean, you go online, you can see all these, I'm not going to name the different companies. You stay up till 3 o'clock in the morning and see a commercial and say, hey, I'm going to call this 1-800 number. I'm going to get a patent. There's a lot of misinformation out there. I do a lot of work with pro bono work, and oftentimes I have helped people that spent $15,000, $20,000, $30,000 chasing their dreams to get their patent, and it's just a ripoff. They file these provisional patent applications, which are not patents.
No, they're not.
They do not grant to become patents. You have no exclusive right to sue anybody. And there's all these promises that, oh, you have a great idea. Let's get a provisional patent, because you can get that. Nobody reviews it. The government doesn't look at it to say, hey, this is worthy of novelty and non-obviousness, all the things we talked about today. It's just it's a placeholder. But that's a lot of what they give you. And it costs $100 and some to file. And then you pay them thousands of dollars to do all their marketing, and then you're cooked.
You hear that?
You get nothing.
Yeah, you hear that with a lot of startups. I mean, all the different startup groups that we're with and the people who pitch ideas to us, and you always get that, and all of a sudden you'll hear this one person, and they always hear, and we're patent pending right now. And it's like, that's supposed to be an impressive catchphrase that is going to make me want to reach in and pull out to invest in your business because you're patent pending. That's a crock of shit, right? Like you just said. And I'm not downplaying.
Can patent pending mean that they're in the actual patent application?
Are they in
process?
the running?
So again, just by filing an application,
It's patent pending.
you're patent pending.
Okay,
See?
gotcha.
So I mean, it's a crock of shit.
So there's
But he's talking about something different with provisional patents.
Right. What I was specifically talking about is this sole inventor, the startup, the entrepreneur that says, I've got something here. Because look, let's be honest. When I say I'm an IP attorney, I'm a registered patent attorney, I got an idea. Here's my idea. Everybody's got an idea, which is great. That's America, right? Everybody's got an idea.
It's like my free consultation, 15 minutes after that, you're paying me. I'm sure the next 45 is going to cost you $500.
We're all paying for it.
Flushes
Darren.
out a lot of people for you, doesn't it?
The thing is that so many folks that have that, they're tempted. Because why? Because they hear the $1 billion stories.
Sure, of course.
And they're like, man, this is it. This is it. My idea. I don't have to build anything. I don't have to do anything. I don't have to go to business school. I can just come up with this. I can get online, pay some rando company $500, and they'll file my provisional application, and then I can sell that to the Fortune 50 companies.
I'm going to save the rainforest with my two-sided toilet paper. I tell you right now.
So there's these stories, right?
Four-sided.
And it's interesting because just like everything else, there are those that have actually, that's the Cinderella story.
Mhm.
They do come up with something, and they're like, well, how exactly did you come up with this, right?
Mhm.
More times than not, it's because they have industry experience. It's because they were solving a problem. They have experience. You wake up one day, probably unlikely that you've got that $1 billion idea that you had a dream about.
Right.
But let's say, oh man, I had a motorcycle accident, and in my recovery, none of the crutches worked. It just didn't work for my problem. So I fixed it to help me. So that's it. I had a problem, and I used that experience to come up with a solution. Now the solution, that's what I see, value really comes.
I had that.
Someone
last
has a
night.
problem, they have a solution.
I did. I had that last night. I was like, I can cure my tendinitis if I would just put an opening in the bottom of my bourbon instead of the top. Then I wouldn't have to twist the pour if I could just pull it out. So
You need a siphon pump.
I'm going to create a
I
bottle.
was gonna say, is that a beer bong?
I'm going to create a bottle that
He
has
needs a bourbon bong. He's Irish.
going to create a bottle that has the opening on the bottom instead of the top. I'm just going to cap the top and create a.
Do you think he's got something there?
Absolutely
Well,
freaking not.
No, he's an idiot.
He's got the idea, but how are you going to teach us? What is it? Don't tell us
Right.
now because this is public.
You just
but,
drill a hole in the bottom of the glass, guys.
If I just actually, what you do is you put the label on you turn the label upside down. You're good to go.
Oh, why
That's
didn't
all.
I think of that? So we've talked about 3 pillars,
Well,
right? So we've talked.
Before we get to the last one, I do have one question about that, and this is relating back to that PX90. So when
P90X.
P90X. So when he
Man, Line
created
Creek's
that
good
product, and he's not the only person who's experienced this, he patented it and everything else, the design, the whatever it is he's got, the system there. As soon as he went to market,
That was copyright.
no, he had the because it's the band, not the PX90, whatever the exercise bands are that they use the surgical tubing for. Isn't that the PX90?
No.
Okay. There's something like that. That's the Navy SEAL guy I'm talking about. But when he created that workout system with the
resistance bands.
Mhm.
it wasn't the
No.
it's not the bands, but it's something like that where you use your weight against you to pull.
You see what I deal with?
Anyway,
It's every day.
the point is he released it out there. It's a huge hit, going to market with it. He put a patent on the design of his product, and lo and behold, our friends over in China made a knockoff version of it. And he went after him. Obviously, he sued him for patent or copyright infringements, but for the design, because they made something. And I know a lot of people go through that, when you're out there shopping on the internet and stuff, and it's like, oh my gosh, I'm going to get this product that's great, and it's a knockoff version. How do you, even if he had a U.S. patent, how can you go after somebody in another country that's replicated what you've done, and your thing, your design is protected?
Yeah. So it's jurisdictional again, meaning you only have true protection in the countries that you have protection.
But
so
you did say there's a little reciprocity around the world.
there are
kinda,
treaties.
sorta.
There are treaties, but that doesn't mean that you don't have to have reciprocal registrations.
Okay.
Right. So you may have, depending on the treaty, depending on the country, you may have some common law rights even in those countries.
Okay.
Otherwise, you need to go pay the piper. You got to pay their government. You got to go through their process. They have to do
Right.
their own examination,
Mhm.
but they'll grant you certain benefits like your date that you filed here, and they'll give you those treaty dates, et cetera. But at the end of the day, you're going to have to protect each country if you want to go after them. But let's just focus on the U.S. since that's where we're at. The U.S. patent or the U.S. trademark gives you protection here. So that means if somebody comes here with infringing goods, you can have customs help you and stop that at the border. You can sue somebody that's making, using, or selling here in the U.S., but even on trademark. So we talk about they're using my trademark to pass off material that's not mine. So they're attacking my goodwill. They're tarnishing my name with bad products. So I need to police that. And if I see that on these e-commerce sites, or if I see it anywhere, I need to go and say, nope, you got to take that trademark does not belong on that product. Take it down.
Birkenstock is another one who had that happen to. I know.
Yeah,
So.
trademark is it's a really active game. It has to be. You have to police and protect your own mark. If you sit back and let it happen, you're gonna let those defenses come in. You're gonna lose those protections. So you have to be out there saying, no, you can't do that. You can't take that. That's mine.
So in the U.S., how do you fight somebody big like? We'll use the company with an A, who just launched a rocket this past month. They're known for doing that too. After people use their marketplace, right? You put your own product out on this one website, and all of a sudden they come in behind you and design a
Well,
similar
I think it's
product?
pretty simple, right?
Okay.
So going back to what you said, so if I've got a patent on a product and somebody sells a knockoff that's a clear infringement on my patent, and my product is sold in Big Mart across the country, and Big Mart brings in some Chinese knockoff because it got great pricing, and they don't know any better. Somebody came with like, oh, here's my product. It's similar and it's half the price. Oh, well, I want that one too. Well, you can go and get an injunction against them immediately because you've got the patent on it, and you can leverage your rights under that patent to make them stop selling it, right?
Yeah. So yes, in short, you have certain remedies.
I know I'm simplifying the
Yeah,
hell out of it, but yes.
But litigation's never inexpensive. Even, I mean, to get a temporary injunction or injunctive relief quickly, it can be quite expensive, and it can be a high bar to win that. So the other way is to leverage your contracts that you have. If you've got a patent and you're supplying a company or you're using another company for distribution, you got to look at their policies.
Mm-hmm.
So you look at a lot of the e-commerce. I mean, all of these. So let's talk about copyright or even talk about e-commerce.
Okay.
They all have their own policies. So you can go to them and say, hey, they're ripping off my copyright. They're ripping off my trademark. There are mechanisms in place. Both, it's not just one of those pillars of law. Look at all the pillars of law, how it's being used. You can use the federal mechanism. You can also use their private mechanism. And I'll just say, like YouTube has a mechanism to take down copyrights. All right. Amazon has a mechanism to handle trademark infringement. They have policy because they know this is a thing.
Well, and they have huge armies of internal counsel. I mean, they've got lawyers on staff. They don't want to get tied up in lawsuits any more than you do.
So the typically, and I'm not specific to any company, but typically they have their own process they go through. You put them on notice, and then they put the marketplace or whomever it is, and they say, hey, here's a notice. You're being accused that this is a ripoff. You've got X days to make it right, or you're done.
Or you're out.
Yeah.
Okay. Yeah, because it's not like the U.S. government's coming in with their own division, going to the Big Mart and saying, you need to cease and desist right now. You have to do it on your own.
Customs. Well, you do. You can
Customs
do. You do have raids that you can have enforcement raids. You can. Customs is pretty strong, and most recently, you have design patents. You can you register these with Customs Office, and they will look at a manifest, and they will hold containers.
Well,
They say, hey, no, this looks like infringing products here, and you got to deal with that through Customs.
that's good.
So we've talked about three of the pillars so far. So we've talked about trademark, we've talked about copyright, and we've talked about patent. So the fourth pillar in IP, it was
Trade secret.
trade secrets. Yes, this could be interesting.
What is in this?
What is a trade secret?
First of all, hold on, because we're in Georgia, Peachtree City, in the area where Chick-fil-A's headquarters is. What is in the Chick-fil-A sauce? Do you have the recipe? Do you know what it is?
I don't.
Oh, damn it.
And if I did, I could tell you, but I'd have to
I
kill
have to kill you, yeah. So what is a trade secret?
So it's in the name, right? It's a secret that gives you a competitive business advantage.
So it's really that simple. I just asked an ignorant, dumb question.
No. I mean,
Really? Well, if you think about Stucky
No,
sauce, Stucky sauce, he switches gourmet sauce, but that's a damn good, unique product. It's technically
Well, let me ask you a
barbecue,
question. So
right?
since we're talking sauce, since Darren is for some reason
I'm
obsessed
hungry.
with sauce, okay, I get it. So is that something that you copyright, or is that a trade secret?
So the way I answer that always is to ask the person that's coming up with it, how easily can someone reverse engineer it?
Damn it.
Because if I can take the sauce and I can figure it out, or I send it to a lab, and they can tell me, hey, here's the recipe, or if you get close to it, whatever it is, sauce is out there in the public. So what's the secret part of it? Well, let's look at the big dog here, Coca-Cola, right?
Right.
So can someone figure out exactly what that is? Can they reverse engineer it? Obviously, the Coca-Cola company thinks, no, I don't think they can, because they're selling it.
Right.
People I'm sure have tried to replicate it, but that's it. Unless they misappropriate it by taking confidential secret information that they shouldn't have access to and share it, that's misappropriation. If they come up with it on their own, if I'm just in my garage and I figure it out, that's the end of trade secret. So that's the downfall. If somebody else can figure it out and compete with you, if I didn't do anything bad, if I'm clean hands and I come up with it, I figure it out. That's it.
So
Your
is
trade secret's
Coke's
done.
formula a trade secret, or is it?
Yes.
Oh yeah,
It is.
It's
I know.
locked in like they always say. It is locked. The original
you know what?
recipe is in a special safe that is locked up.
Their recipe is so good they couldn't even improve it with new Coke.
If you
you
go,
remember that shit?
I do.
It was horrible.
But
oh,
have
we
you
made
ever-
it better.
Little
Mhm.
aside, really quick, entertain me for a second. Have you been to the Coke Museum up in Atlanta?
No.
Okay. So when you finish the tour, and it's a pretty impressive tour, it's a lot of fun, but you wind up in the Coca-Cola room, we'll say Coke room, but it is all the different Coca-Colas that are distributed around the world,
Yeah, they have that at Disney too. I've done
And
that.
but they're all different flavors.
Yeah.
So it's like, well, the original Coke wasn't good enough for the rest of
You
the
walk out of there like Cornholio.
Yeah. But they only have a patent on the original Coke recipe, I'm guessing.
No
Well,
patent,
they have
right?
an-
Trade secret.
Or
Trade
trade
secret,
secret
because
on the original,
what's
but
it-
not all the others.
Well,
Do
one,
they?
who knows?
I don't know.
You know, I would say
How do you
probably,
find
right?
out?
Because here's the difference. And I'm glad you mentioned patents. Patents are published. The whole point of a patent is you're going to share with the world. Here's
And
how
you
I,
have 20 years.
here's
What
how I
you
do
have.
it.
Then
So,
anybody can make Coke.
There's always an exchange. If you
Ah.
find out, you know what, someone can reverse engineer my recipe.
Mhm.
They can figure this out. Then maybe patent's the better route because you have something new. You get the exclusive right.
You're
If you think you can
protected
get
for-
it granted. But if you don't think someone can reverse engineer it, they're not going to figure out what your secret sauce is, then you can keep that for secret forever. Right? And then that's it. That's very powerful. And so what do you get out of trade secret? What you get out of it is you get now protections. There's a federal law that wasn't always there, but it's there now. And if you follow certain rules, like you have to demonstrate, yes, I take effort to keep it secret, which means what? I mark things confidential. There's only a small group of people that ever get to see it. If they get to see it, or if they take a tour or whatever, they have to sign NDAs. I keep a logbook. People come in. What you have to prove to them, this is a secret, and then they're going to give you that benefit. You'll always, once in a while, you'll see someone that leaves one of these big companies, whether it's a soft drink or software manufacturer, and some employees try to sell trade secrets to another company. It's most often the receiving company that says, I'm not touching this.
Mhm.
And they turn them in. And they're like, hey, your ex-employees just tried to bring me information and we didn't look at it. We don't want it.
Right.
Justice Department, you deal with these guys or whomever, you know.
So let me give you a hypothetical. So disgruntled employee gets fired from Coke, and they say, you know what? I'm publishing the Coke recipe online. This is bullshit. I hate these guys. And then they publish that recipe. Once it's out in the open, then what? Is Coke still protected?
Well, the secret's not. So
Right, so
under
it's out
trade
in the
under trade
open.
secret, it's done. But this is why they go through all those efforts to say there's nobody in a position that's going to be able to out it that way. Maybe they have other trade secrets, maybe some lower level trade secrets
Mm-hmm.
that they're trying to trade on.
Mm-hmm.
And typically when they try to sell those or they try to use those to get themselves an advantage with a competitor, because most of the time they're not just pissed off so they're going to just publish it. They're going to go somewhere and try to make some money or get a better job. And in those times, more times than not, they say, no, we're not going to touch that. And if they don't, then a lawsuit follows and they say, hey, everyone now needs to keep this secret. And the people that are trading on it, now you have to pay damages and you have misappropriation and maybe some further issues.
Oh, that's fascinating. So let me bring this into kind of the small business realm, because I actually have things in my business that I actually think are trade secrets. So we've figured out ways to do things that we don't want the general public to know. It's actually in my agreement with my employees. I actually have a trade secret section in there that my attorney drafted up. And so we actually kind of keep that close to the vest, but it's only a contract between me and somebody that's on the team. I don't really know what to do with it beyond that. I mean, is there ways to protect yourself as a small business if you have what you consider trade secrets?
The agreement is a good place to start.
Mm-hmm.
And then the other things are just policies. Because let's say one of your employees decides to take that. And one of the common things that people don't think about, but in sales, maybe I have a preferred client list. I know my top 20 clients
Mhm.
that keep buying this. That list can be a trade secret. Because why? I spent 20 years selling in the industry, and I know these are the best people, the best regions, or the best vendors. Any bit of that information could give you a competitive advantage, and it's my list. So if one of your employees decides to take that list with them and start their own competing company using that list, you started with the agreement.
Mhm.
You have a contract that said, this is confidential, this is our trade secret, you can't share this, that's part one. So the kind of entrance interview is big.
Mhm.
Everyone understands that. Look at this provision. You know what you're signing. You have an employment agreement. Then the next piece is, what do you do while they're employed? Well, I keep reminding them, this is marked confidential. All right. We know who has access to this. Not everybody. It's just you as the sales team. That's it. You cannot share this with other people. Accounting never sees this. Just the sales team sees this list. And then you do an exit interview. And you say, remember, you signed this. Can't take anything with you. Leave your laptop. You can't, you go through that whole process that proves to the court that this is serious. So if they go ahead and violate that, you have all the evidence to say, no, there's no question. Look at all the steps that I took, and they still went and tried to take it.
So this is actually really, I'm glad you're saying this, because one thing that I don't do, and I'm just, kind of airing my dirty laundry here, is I don't mark things as confidential. I tell people that these are like, hey, this is our secret, this is our deal, but I don't mark it as confidential. Or a lot of times I'll talk about something at a meeting, and I don't document, I don't hand anything out, but I'm talking about like, hey, this is our deal, so this is not for public consumption. Am I protected in that case, or do I need to document that we're talking about things in this meeting that are confidential?
So are you protected? You're protected as far as the law protects those facts, but evidence is a whole nother thing. So if you have to come along and say, no, that's what we said.
So if somebody goes out and they start spilling the beans, and they're like, so the court's going to say, okay, well, so you talked about something in that meeting. Where's the documentation that it was confidential?
Or other evidence. Documentation is one form of evidence, but you could have other ways.
Employees saying like, "Oh no, they said that we weren't supposed to share this." That could be.
I put 6 people on the stand, and everybody says, "Oh, we all know that. You don't talk about that. You can't."
Okay, well that's fair actually, and that's a really good point, because this is something that I do think small businesses do run into, because Darren, in the real estate business, we do have trade secrets. Like, we're doing things that we know other people aren't doing, and I don't want that out there for public consumption.
Yeah, you should probably mention that from time to time.
Yeah, thank you,
Just
Darren. I need to step up my game there, but that's actually really good. And I'm
just
actually, now that you've said that, you've triggered, like, right off the top of my head, there are certain things that I want to go put confidential marks on.
Yeah,
it's a good thing.
Oops.
Well, at least on the bottom, like,
Yeah,
you
confidential,
know
not
that
for public distribution, whatever.
working for Mullinsboro Realty, on the bottom of my emails, I have that little tagline, "This is confidential," and blah, blah, blah. And
Yeah.
if you've received it and you weren't supposed to, get rid of it right away.
and that's one step, marking it, but it's really practice what you preach. So if you mark it, but you're giving it around to every,
So that's
and
actually
anybody, then they're going to look at it and be like, I don't really care what it says. Everybody in Peachtree City has a copy of this.
Yeah, you're an idiot. No, actually, one of the things you just said that I think is really smart, in probably the bigger piece of this. So if you are involved in trade secrets, I mean, we're talking about legal protections, but nothing takes the place of the actual protection. Like, we were talking earlier about KFC, and I remember reading about this at one point, but they had, like, I know one of the things that they did, maybe they still do this, but there are only certain people in the company that have certain pieces of the Colonel's original recipe. So, like, officer number 1 has 2 ingredients. Officer number 2 has 2 ingredients. And so everybody's got their own, but nobody knows what everybody else has. And so, this is seriously a freaking thing. And that's how they're keeping their recipe a secret, is like nobody knows the whole damn thing. Everybody's got little piece parts of it. So in actual practice, the more you can do to actually physically keep it a secret, the better.
Yeah. Yep.
Going back a little bit, you mentioned NDA before. Just
Non-disclosure agreement.
Non-disclosure
if you don't know what that means,
agreement. Yeah, thank you. And so we come across that a lot. we have people who are
No. You come across restraining orders a lot. That's different. It's similar.
How good are you at filing restraining orders? Or if a restraining order is filed against somebody in this room quite often, can you help
Somebody
me get
named
that
Darren.
bucked from the system? No, but anyway, regarding NDAs, because a lot of people are scared to share their idea, although it would benefit them a lot more. And I went through that once. I had a great idea, but I held my cards so close to my chest that I missed out on that opportunity because I was afraid that once I shared my idea with someone, that they would go to market faster than I was. And I know a lot of you hear that, no, that's not true. But anyway, should you have a non-disclosure agreement? When is it important to have a non-disclosure agreement, really?
I mean, academically, always, right?
Always.
But then practically, it slows down everything.
Oh yeah.
Or it can, right?
Mhm.
I've had some experiences that I would not apply everywhere, but it's really interesting when you have a really interesting product
Mm-hmm.
to certain buyers or certain vendors, the NDA won't slow it down. It just won't. So
Okay.
then it just begs the academic question. So what about all those other cases where someone says, "Well, we don't do that. We don't sign an NDA." Do you really have something? Are you barking up the wrong tree? I don't know. There's
Right.
always the business story. Here's the problem. You're playing probability. There's always the business story, the Cinderella. I've got something, and that Fortune 50 companies, once they hear it, they're going to buy it. And I've done deals with solo inventors selling to like the big three auto. Like it has happened. But they kind of knew they had something. They've been in a machine shop for 40 years.
Mm-hmm.
They actually built something, and they're like, "Oh, this is for real." Right? So those are really the instances where they're approaching the big dogs, and they knew that an NDA wouldn't be a problem because it's for real.
Mm-hmm.
All those other situations, I say the same thing. I'm like, if you can get the NDA, do it, because I mean, really all the NDA gives you is the right to take them under contract law to a state court.
One of the things that if I could, Darren,
ahead.
because I'm going to answer your question a little bit, because I've had situations like this in a startup where you never knew, right? So one of the things that I did as a common practice is I had a boilerplate NDA with me always. Like I had blank copies. So if I'm sitting there talking to somebody and I'm like, we're getting ready to cross over, you know what? Let's talk about it, but I want you to sign an NDA first. I'd whip it right out of my bag. We'd sign the NDA and continue the conversation. And I think that's a good practice. If you're in that space where you think you have an idea or, a business process or whatever, and you want to talk about it freely, just have somebody help you put together a blank NDA, and then just be willing to have that with you at all times and just sign it if you get into that space.
And the other thing, though, in those scenarios that are moving quick and kind of bleeding over, what is the confidential information? Because the NDA is going to give you a scope and say,
right,
this is confidential information. This is not confidential information.
right.
It's usually what I tell you is confidential information, but you kind of talk to me for 2 hours, and then we talked about something else. So you're blurring that a bit. So what is the sphere of what is confidential and not? First of all, are you really going to take them to state court and sue them under contract law and say, you took my confidential information? I mean, what remedy you're going to get? Who took it? What are they doing?
Yeah, we talked about my mom, and you said something about my mom. It's like, no, that the scope of your NDA was for your business idea, not your family, right? Silly idea, but it's the same premise, right?
But even further than that, to think about enforcement, right? You want it because everybody says, I just need some protection because I always think someone's going to take it and they're going to make $1 million and I'm left out.
Yeah.
Right. What do they call that? Fear of missing out, right?
FOMO.
Yeah. So I've got that. They're going to get it. They're going to take it. They're going to capitalize on it, and they're going to screw me over here.
Right.
But at what point are you going to be able to see that, take them to state court, and have the money to because you're not going to necessarily get damages out of that. You see what I mean? So there's a lot of problems even with the NDA to begin with.
Well,
enforcement is not the least of them.
How well does an NDA hold up in court is a good question.
And again, if you have good sphere defined,
Right.
This is my confidential information. We met on this date. This is what we talked. We knew this, and we're going to part ways, and that's it. That's That's pretty strong.
I do that with consulting. I mean, I'll have somebody come in and they don't have one, and I'll be like, you know what? We're going to sign an NDA.
We're going to sign an NDA.
Started.
I do not want you to disclose how terrible of a consultant I am.
But no,
we call that a non-disparagement clause. It's a little different.
It's a whole agreement. Is the non-disparagement part?
I'm having them sign the wrong thing, but I create one for them because they're getting ready to share their ideas with me, and I'm like, listen, I want you to be protected. I want you to know that what we're going to talk about, you're covered. You're protected, and I'll do it for them. And it's almost like I'm teaching them the habits of having an NDA for whoever they're going to get together with in the future. And they're looking at me and they're like, well, I hired you. And I'm like,
yeah, it's a
but
good practice.
You need to protect yourself. Okay. So, but I don't know if that's for what version of IP that falls under. Obviously that would be trade secrets. That might be patent, but that really doesn't fall under copyright or trademark.
Well, it's confidentiality. It covers all of those things.
Even
because those things are how do you protect my confidential information in a particular avenue of intellectual property? But the base confidential information, what you're talking about, that's all. It's just typically a state law contract.
Okay.
So if it says this NDA is governed in Georgia, so what you have, I take your idea, I go and use it. You don't have a patent yet. You're not going to sue me under patent law. All right. You don't have it. Maybe you don't have a trademark, whatever it is.
Right.
How are you going to sue me? Your remedy is to go to state court and say, Mike breached my contract with him by disclosing the confidential information.
Okay. And
that's it.
Right.
So Mike, one of the things I'm really interested to talk to you about is since the pandemic started, a lot of stuff has changed. A lot of things have gone online meetings, and people trying to change their business models. And what are some of the things that have happened in the IP space since all this got cranked up?
That's a big question as well.
I know.
I mean, we already went digital, right? I mean,
oh yeah.
Which brings up a couple different things. We talked about trademarks being local. Is anyone really local anymore? You got a website. You're selling, you're reaching out. People can buy your candles, for anywhere, right? You have good commercial reach now. So the idea that, just because you put someone's brand on it, oh, but I'm here in Georgia and they're in California, there shouldn't be a problem. Well, probably a problem. If they're selling candles under the name and you took the name, you can't cry over it because you didn't do your diligence.
Well,
right?
I spelled Yankee candle differently than they spelled.
That's right. I added 2 more E's.
Right.
Yankee.
Yeah.
It's actually a really good point because I think a lot of people are like, oh, I'm just doing this little side hustle. And, unfortunately, a lot of people have been forced into major life changes because, their business went belly up or they lost their job or whatever, which, really devastates me because so many people have been impacted by this financially. But we have seen a lot of people get creative and do some really great things throughout this pandemic or change their business model. We've had people that were, dependent on physical retail locally and completely switched to being online. But that's a great point because so many times that small, let's say you're making candles, right? Use that as an example.
Sure.
Well, I'm doing Jake's candles. No big deal. I'm selling candles. I'm going to put them online. But Jake's Candles is a major regional distributor out on the West Coast. Well, I don't know because I didn't look into it. I don't care. Just a little small guy doing my little business, whatever.
Yeah.
That could be a problem.
Yeah.
Big time, right?
Yeah, can be. I mean, I get calls, and it's always hard when it is the startup because they're like, oh, I just got this letter from out of state, or worse yet, I got a letterhead from a law firm representing a Japanese company, and they said they're going to, come after me, and this is bogus, and I'm like, well, is it?
Is it?
Right.
Let me take a look at that.
Well, and it sucks. It sucks to get that because it's typically, hey, we're just on the verge of making it, and now this is holding me up, right?
So there was, let me try it. You know what? I'll save this for after because I don't want to ask this on the air, but we'll talk about it in private after the fact. Sorry.
What the hell are you talking about there?
It's
This is, again, more of Darren's
No.
legal troubles.
this is serious. You'll understand it after the fact. Sorry, folks. I didn't mean to start to broach the subject and then
He didn't
pull
mean to be
back on
Darren,
you.
folks.
Yeah, and if you
It
see me on my
happens all the
phone, I'm not checking text messages. I'm stopping and starting Darren's time clock.
You know what kind of bill I'm going to have after this? I'll tell you what. We were in the car. We were riding over to
Let me
pick
get a
up.
peek at it before you send it to him. I want that satisfaction.
Yeah, we sat there in the car today, and I said, you know, the other day I asked Mike a question, and he gave me, for about 10 minutes we talked. And I said, I'm just waiting for the bill, because that was probably $600 worth of information that he gave me there in 10 minutes. So I know the bill's on its way. So
Jesus, I have to podcast with him. Do you seriously? Do you
I'm
feel bad
aware.
for me?
I'm aware
Why?
of that.
You should.
he doesn't have any of his legal expertise is in fields that I can't utilize him.
Yeah.
We know I don't have any good ideas that need to be patented or copyrighted or trademarked.
So going back to your point earlier, so it sounds to me like a lot of what you guys are dealing with, it's not new since COVID, but probably accelerated or amplified, right? Because one of the big things that we've seen, just as a macro trend, is so much physical retail get moved to online or some hybrid model. Great example is Kroger. Well, I don't want to go into Kroger because I don't want to get sick, so I'm going to do the click list thing online and go pick it up. And so much has been moved to deliver to the house or pick up or whatever, which means online. That's not new. It's been around, but it's probably higher in volume. And I think a fair statement is probably thrusting a lot of people that never would have thought that they'd be dealing with IP issues right in the middle of it.
Yeah, no, acceleration, that's a good word. That's absolutely the case. And when someone's looking to kind of, whether it's a side hustle or whether it's something more,
Mm-hmm.
there's always this shoot from the hip type of understanding of intellectual property. When someone gets online, they do a search, they see Etsy, they see all these other people, they see YouTube, whatever, and they're like, everybody's doing, it's the Wild West. You can do whatever you want. Nobody's getting, no individuals getting hauled into federal court by Disney because they were doing a collection of Disney princesses.
Mm-hmm.
And I'm like, that doesn't mean they can't.
Sure.
Right.
So
but
it's risk management.
But let me go. I want to go back to something because I'm going somewhere with this, because I think a lot of times when people think intellectual property, they think about protecting themselves from the standpoint of somebody coming after them, right? But there's another side of this, and I want to go back to what you said earlier. So one of the things that's happened is all these people have gone online, and they're doing things online, they're doing videos online or what have you. So this could also be flipped, right? So if I'm somebody that has, I don't know, had some fitness routine that I put on YouTube years ago, and that's been my deal, and I've done really well with it, and all of a sudden I find that there's somebody else out there doing the same thing as me. And I'm like, man, oh, shucks, that's bullshit. They're taking my ideas and, they're doing really good with it. But they may be protected, right? Because that other person was there doing it first. So if somebody's taking content that I created, my process, even if I didn't trademark it or patent it or whatever, but they take it and they copy it verbatim, I might be able to have a claim against them and say, they took my stuff and they're just recreating it in this new world, and that's not fair.
Jake.
Right.
Jane Fonda's workout, she created that before you did, okay? Just letting you know. I know you think it was an original thing on your part, but Jane was first.
You just hate things so bad, you get your blood boiling and in your lungs going, and all of a sudden you're in shape. Is that what the Jane Fonda workout is?
There is.
He's like, I'm not even touching that shit, guys. Smart man, Mike. He is a lawyer.
But there is kind of a surge of new content, and it's the personal brand content, right?
Is it?
So, what I mean by that is you've got a presence on any one of these social platforms posting all this content, and I mean, you're creating copyrightable content. So in one vein, you're commercializing on your own brand, and you better make sure that you've got the right things in place, because if it takes off, you want to be able to say, this is it. This is what I'm protecting. On the other hand, you kind of feel emboldened to say, I can do whatever I want. I can play whatever music in the background. I can,
Oh, no, you
I
can't.
can do whatever I want to do, because why? Because it's the internet. Who cares? So it's interesting, because once you rise to that level, you're going to draw all kinds of attention.
So
And maybe you're flying under the risk management radar 1 minute, but then you're not the other minute.
is that like the influencers that you're talking about on the internet?
Yeah,
Or are you talking about anybody else?
Nobody cares about getting into your pockets until there's something in it.
Right. In influencer, yes, but
They're
even
creating a brand.
even broader than just an influencer, because I think there's so many sectors where that definition is broadening out. I don't need 100 million followers to make an impact. Like, you have content, there's lots of different ways, whether it's music, video,
Right.
any content that you're putting together. The question is, where are you getting your content? Is it original content? Is it your
Sure.
original content? And if it is, we go back to your comment. Someone rips it off, you might have a claim.
Well,
How are they using it?
Back in the day, and actually I shouldn't say back in the day because it's still occurring today, you have in the music, you mentioned music. So if I own a commercial business and I'm playing music over for everyone in the office to hear, there are a couple out there. There's ASCAP and
BMI,
EMI, and there's
Zach.
BMI, and there's a third one.
Harry Fox.
But they want a licensing fee to play that music. You have to pay them a licensing fee to play that music in your establishment,
Right.
restaurants, etc. And then they actually have certain playlists from different artists. So they're like, I've asked, guess what? You better have BMI, because they have other artists playing different. It's that crossover. So you're out there and you're like, now we look at TikTok, right? And there's all these people doing dances to these songs. I'm assuming TikTok has made agreements with the artists to pay them for all these people to dance to their music.
Assume nothing.
Well, as
I'm just questioning, because that's a huge infringement. I mean, as a business owner here, and if I'm playing your music, I got to pay a licensing fee. And the whole point, as we understand it, the licensing fee is there that all the artists whose music you are playing to listen to in your restaurant are getting paid a little bit of money for their songs that are being played on the radio there. So how's that work with something like a social media platform like TikTok?
yeah, well, it's not as clean as simply playing it at your restaurant or bar,
Right.
because what you're doing is you're putting it in video. And when you put it in video, you now require what they call synchronization. So
What is
it's the synchronization of the music recording
Mhm.
that's being played or copied,
Mhm.
and then the video. So that sync license is not covered by the mechanical license. A mechanical license is what you get when you want to say, hey, I'm going to play this on the radio, or I'm going to have a cover band. But once you have a video, now you need a sync license. But for a sync license, you need to go back. It's not to Harry Fox. It's not to the
Is it to the recording company?
it's the rights owner,
Okay.
whether it's the artist or the record company.
Right.
And you negotiate a synchronization license to put it on that video component. So the audio video work is typically under that different license, because there's all these different lines. So it gets much more complicated, because you're like, oh, well, I've got this, or I'm just covering. I can do this.
Right.
Well, you put it in video, things get really out of whack, because it's required in a whole nother license, which isn't covered by that mechanical license. So then the assumption that, I'm free to use it is incorrect. Let's just look at YouTube, for example, because I've looked at their processes quite a bit. They actually have their own system of detecting copyright infringement.
Yep.
And they will go back and they will say, actually, someone registered with us
Mm-hmm.
that they own this copyright. You infringe this copyright. So all of our ad revenue from Google Ad is going to go to them now. And they have elected to allow you to keep your video up, because they're going to make money off of it. So you have 100 million clicks.
Mm-hmm.
You're not getting anything from ad rev.
Mm-hmm.
It's all going to go to the owner. Or they have elected to shut you down.
Mm-hmm.
So you can no longer have this. So they have their own internal process, and you can go through a process, you can appeal. Interestingly, that's still not the federal courts. There's still that option out there, but what they've created is their own internal policy because they have so many subscribers doing this.
Right.
They said this is going to be a lot easier, and probably the rights owners, the copyright holders, are going to like this better because they don't have to keep suing people. We'll make it simpler for them.
Well,
So that's a good example of sometimes the federal laws as it relates to IP don't need to be enacted because there's a contractual agreement between two private entities.
Pretty much.
And nobody's going to take it to that venue, right?
Pretty much.
Yeah.
It's rooted in that because why would I agree to abide by their policy, but for the fact that otherwise I'm infringing a federal copyright, right?
Yeah.
So on one other question, you were talking about T-shirts, coming up with cheeky catchphrases or whatever. So, but what if you see all these T-shirts that are taking quotes from movies, and we'll use T-shirts, and they're a broad platform for that, but I'm going to stick with the T-shirt, and you're extracting, I love this catchphrase from this movie, like "as you wish," or
I'll be Bach.
see anything like that, and you put it on a T-shirt. Technically, that's a line from a Are we crossing lines?
It's a
there
line from a
too?
super smash hit
I mean,
box
can I
office
be
movie.
if I start if I start putting that on my T-shirts, can I get sued for that?
So it comes down again to what is the word we use is with the black letter of the law. What is the law? We can give you that answer, but the practical answer might be: are you really going to get sued? Probably not.
Probably.
Could you get sued because you're violating
Sure.
the black letter of the law? Well, yes, but there's a determination in there.
Mm-hmm.
In a lot of IP, the courts have said, how do we interpret whether you infringe or not? So they come up with all these tests. Oh, for this, we're going to use this test. And they're going to go down these four questions or 9 questions.
Okay.
And that's how they decide. And, I'll go back really quickly. There was a case, and it was about Nixon's biography. And they wrote this, or autobiography, and it was like, let's just say it was 900 pages long, okay? And a guy took out whatever, 1 chapter, 5 words, whatever, some tiny portion
Mm-hmm.
of the whole book, and took that out and published it. And he got sued. And they said, no. He goes, I didn't copy the book. I only copied this little piece right here. This is all, that's it. And he goes, yeah, but that was the part on Watergate.
That was the relevant part.
Why did nobody cared about, what his favorite sport was when he was 9 years old. They wanted to hear the guts about Watergate, and that's the part you copied.
Mm-hmm.
That was the heart of it.
Yeah,
And therefore,
exactly.
you're in trouble.
Oh wow.
And like going back to Darren's T-shirt example. So like if I was to create a T-shirt and sell it, and it said "I'll be back," and it had a picture of Darren with sunglasses on it, right? And it was kind of a play on it. Everybody knows that I'm like doing a parody off Terminator, but am I going to get sued for that? Probably not. But if I was selling T-shirts that said "I'll be back," and it had Arnold with the sunglasses, holding the shotgun from the movie, I'm probably going to get in trouble for that.
Well, you got a couple different pieces there. Plus, you brought up the idea. You threw out the word parody, right? So now we're into this whole space of fair use, which I think nowadays people love to go online and Google fair use and say, everything's fair use. I can do whatever I want. Fair use, right? Well, it is powerful. It's a defense that applies in certain situations. And one of the ones that people like is, are you making commentary? Is it a parody on something else? And that doesn't mean you're not infringing. You are infringing the copyright, but your defense is, it was fair use because I was making a parody of this. I was making a commentary on that.
Is that the trigger that people use? Like if they're on YouTube and they're playing back a video from somebody else and they're making commentary on it? Are they using a fair use argument that they're doing that?
I don't know, case by case, because we won't know until they get sued.
Ah,
And then they call.
that's a lawyer
then they
answer
call
for you,
Mike.
folks.
So, well, I'll tell you what. This is holy crap. Yeah, we could go on for hours, and
But you
Is there
were in
anything
the
else?
middle of answering something, so I'm going to go back to this.
No, I
The
think
fair use thing.
no. I just wanted to bring that out there because it does exist. It does work. It doesn't apply to everything just because you think it does,
Mm-hmm.
right? If you're out there commercializing something and you're making benefit off of it, you know, but you say, oh no, it's fair use, you know, make sure you know what you're talking about and how that applies.
So if I were to do like the parody T-shirt with Darren and sunglasses and I'll be back, I probably want to talk to an attorney
Why
first.
wouldn't you? Well, for multiple reasons, you want to talk to an attorney. First of all,
Well, if I wanted to
my
sell
face
T-shirts,
on
I
it.
wouldn't put his face on it. But you get my. But that's probably something you'd want to talk to an attorney about. Like, hey,
Sure. Hey, you know, real quick.
what do you think about fair use in this case?
Yeah, we call it clearance, and you know, it's always better to have clearance to say no, you don't infringe, because otherwise you're saying, well, you do infringe, but if you get sued, here's your defense. A defense means I might be in court trying to defend myself. You know, the other side is no. If they send you a letter, you say, actually, no, I don't infringe, and here's why.
Okay.
It may keep you out of court as opposed to just saying, all right, you're right, I did wrong, but here's my defense. I shouldn't get in trouble for it.
Yeah.
Protect your ass.
That's
Do it beforehand. Yeah, assets. So, I mean, there's so many things that we covered today, and we keep going. But in the end, when I'm sitting here, it's like, you know what? I think the best defense is to start with an offense. And if you are going to copyright anything under IP, go seek out an attorney like yourself, at least for a consultation to start with, and find out if you need to protect yourself or how you need to protect yourself.
well, and I think one of the most
wrong?
important things you've shared with us today is that, you know, these aren't always black and white issues, and they tend to cross multiple areas of law.
Yeah.
And I think the biggest thing is, you know, in so many entrepreneurs are notorious for this. We just get it in our head like we're doing something and we go full steam ahead. And it's like lawyers, I'll get to you like when I need a contract, when I'm
too
in
late.
trouble.
Yeah.
Exactly. When, oh shit, I'm getting sued. Oops. But this is one of those areas where I hope we've opened people's eyes today on some of the things that you might want to be thinking about and be proactive about. Because I think the biggest thing when it comes to IP is being proactive, whether that's a defensive strategy where you don't want to get in trouble, or it's an offensive strategy because you got a great idea and you want to be in pole position, or whatever the case might be. You create some content, you know, you've got marks, a name, whatever. Like, you know, there's times when you really need to be thinking about this before you need it.
Yeah.
Fair?
Yeah. And the other thing I'll say is when it comes to business, especially entrepreneurship, there's a lot of emotion that gets involved in it. And
Darren cries every day.
that's right.
And he snuggles
He's
up
like,
next
yeah.
to me crying too. So it's
Well,
like,
you know, misery loves company.
you're over there crying. Can I join you?
That's right. The emotion is good because that's what, you know, that's the passion that gets behind the business, right?
Right.
But the emotion can cloud it.
Absolutely.
So you say, oh no, this name, it has to be called Sarah Lee. Because Sarah Lee was my grandmother's name and she made this pumpkin pie. It has to be Sarah Lee. Yeah. Okay, good luck selling pies.
Well, you're is what you are.
Yep.
Yeah. Have you ever been to a store? Have you ever been to the frozen section? Yeah, you're not getting that one passed.
So we're going to give you a little extra pitch here because I think you need it, especially for spending a couple hours with Jake and I in the studio.
Yeah,
And
you deserve,
we appreciate it.
You deserve some compensation. But sgrlaw.com is your website, right? So I can't remember you have a very lawyerly sounding firm. It's, what is it again?
Smith, Gambrell, and Russell,
Gambrell.
over 125-year-old firm out of Atlanta. Offices from LA to New York to Miami to London, and you know, full general practice firm. So corporate, setting up your LLCs, tax, IP, obviously, entertainment for those that are in music, movies, down here in Fayette and Coweta.
That's you, though.
Got,
I mean,
got a
under
lot.
your specific, what areas do you practice?
Yeah, intellectual property and entertainment. Yeah, I co-chair the entertainment group at the firm. So, yeah.
So if somebody is interested in talking to you about IP or just talking to somebody, should they go through the firm or should they reach out to you directly?
If you're on the firm website, you can find me, Michael Riesen, or just go to the entertainment side or IP side, and you can reach out to me or anyone on the team.
Cool.
Did you hear how I pronounced that? It's Riesen.
I
Well,
know.
we do. I do pronounce it incorrectly.
Like
Is that
bad
right?
moon, horizon.
That's
So wait,
right.
it's you. It's not me.
No, it is me. It is me. So every time I go to Europe, I pronounce it the right way, which is Riesen. So
I
Because
give
the
up.
I before
blame-
E
it's-
over there.
You know what it
which
is? It's Mike.
flips it.
That's what it
it's
is.
Mike. That's all it is. Don't worry about the last name. It's Mike.
So it's sgrlaw.com. If you're listening, it's in your show notes, so you don't have to remember that, and just click on the link. Whatever platform you're on, you'll see the link to sgrlaw.com. Man, I really appreciate you coming on. This has been a really cool conversation. I think we've gotten into a lot of stuff here that you helped educate me on. I know you educated Darren because he's an idiot.
For sure.
And hopefully our listeners too. So,
It was fun.
yeah, man, appreciate it. Folks, thanks for tuning in. We will see you next week.
See you.